Good morning, everyone. It's really a pleasure to be with you today, even if virtually, for this NYLP Legal Leadership Forum training session. I'm Joanna Lameh, and I will be walking you through one of the most fascinating yet complex areas of law, construction disputes. Now, I want to be honest with you from the start. This topic is vast. One session all alone cannot do it justice. It usually takes several sessions and, more importantly, practical hands-on experience to really understand it. But my goal today is not to overwhelm you. Rather, it's to give you a practical glimpse into this sector, highlight the most common challenges that arise in construction projects, and leave you with valuable insights that you can build upon as you progress in your legal careers. Therefore, think of today's session as your first step into the field, an introduction to the real-world issues lawyers face, the kind of disputes that constantly arise, and the mindset you will need to tackle them effectively. By the end of this session, my hope is that you will not just have listened, but you will walk away with lessons, insights, and curiosity to explore this area more deeply. Let's begin. Before we dive into disputes, every construction dispute begins with understanding the parties involved. Typically, you will find three main categories: the employer, or also known as owner or client, the one funding and owning the project; the main contractor, who's the party directly contracting with the employer to execute the work; the subcontractors and suppliers, who may take on specific tasks if the main contractor outsources part of the work, unless restricted by the contract. The employer and contractor agree on a time frame, on a scope of work, and from there the project begins. Sounds straightforward, right? Well, that's on paper. In reality, things gets often complicated. So, for example, imagine an employer who wants to build a hotel. He will sign a contract with the main contractor. That main contractor might decide, okay, I will handle the structure, but I will subcontract the finishing, the electrical works, or the facade to other companies. Unless the contract specifically forbids it, that's completely normal. But remember, the only legal relationship the employer has is with the main contractor. The employer doesn't deal directly with the subcontractors. That's where a lot of disputes start to arise. Now that we know the players, let's talk about the rules of the game, the contract itself. A construction contract might be very simple. Sometimes it only sets out certain specific terms and conditions the parties agreed upon. And when the contract is silent on a certain issue, the matter will fall back to the applicable law. This is especially important in civil law jurisdictions. However, major construction contracts go a step further and make reference to FIDIC, which has become a global standard. For those who have not heard of FIDIC before, FIDIC stands for Fédération Internationale des Ingénieurs Conseils, or in English, International Federation of Consulting Engineers. It's a global organization headquartered in Geneva, Switzerland, and is best known for publishing standard forms of contract widely used in international construction and engineering projects, such as the Red Book, Yellow Book, Green Book, and Silver Book. Going back to our point, if a contract refers to FIDIC, you will actually find two sets of conditions: the general conditions, which are the standard FIDIC provisions, and the particular conditions, any modifications, deletions, or amendment that the parties agreed upon them. Going back to our point, if a contract refers to FIDIC, you will actually find two sets of conditions. First, the general conditions, which are the standard provisions of FIDIC, and the particular conditions, which include any amendment, modification, deletion, or addition that the parties themselves agreed upon. And here's the important part of when there is a conflict between the two sets of conditions, which one would prevail? The particular conditions will always prevail. Another point worth noting before moving to the practical challenges. FIDIC contracts typically include an arbitration clause. So unless the party is specifically excluded in their particular conditions, disputes will generally end up in arbitration rather than national courts. So whenever you're dealing with a construction dispute, ask two questions. Is there a reference to FIDIC in the contract? If so, what do the particular conditions say? Because that will determine not only the substantive rights and obligations, but also how disputes are resolved. Now let's dive into the practical challenges. Challenge number one, delay and penalties. One of the most common disputes in construction is delay. So here's the question. What happens if the contractor doesn't finish the project on time? The answer is they may face penalties or what is called liquidated damages. Now let me pause here and explain how the liquidated damages are calculated. It's fairly straightforward in theory. The contractor will usually specify a daily penalty rate for delay. So if the contractor fails to complete the work on time, you take the number of days of delay multiplied by the daily penalty amount set out in the contract. So for example, if the contract says the penalty is 10,000 dirham per day and the project is 30 days late, the calculation would be 30 days multiplied 10,000 dirham. It will give you 300,000 dirham in liquidated damages. But there is an important safeguard here. These damages are almost always capped at a maximum limit, usually a percentage of the total contract value. In UAE law, that cap is commonly 10% of the contract value. So even if the project was delayed for a year, the employer can just keep charging forever. Once the cap is reached, no further liquidated damages can be claimed. This is why both sides pay a lot of attention to the daily rate agreed in the contract, the cap, which is often heavily negotiated during the contract drafting. But are the liquidated damages automatic? No, not always. The key question is here, who caused the delay? While there is a legal presumption under UAE law, for example, and other civil jurisdictions, that the contractor is at fault if there is a delay in the project. Hence, the employer will be entitled to liquidated damages. This is not the end of the story. The contractor can still defend themselves by proving, for example, that the employer ordered some variation works or delayed interim payment throughout the project or instructed additional works to be carried out beyond the original contract, and so forth. In all of these cases, the contractor can argue, I'm not responsible for this delay. And usually, given that each party is bound to produce evidence to prove its allegations, both sides usually bring in delay and quantum experts to back up their arguments. The expert reports often carries huge weight with the court or arbitral tribunal. Ultimately, disputes around delay often heavily depend on expert findings, given that it's a technical issue. And the decision will swing either toward granting the employer liquidated damages or granting the contractor an extension of time and prolongation cost. And remember, liquidated damages and extension of times are two sides of the same coin, and you cannot have both simultaneously. Either one applies, and it all depends on who's actually found to be responsible. Let's move to challenge number two, concurrency. What if both sides are at fault? This brings us to something called concurrency. Let's say the contractor was slow because of a labor shortage, but at the same time, the employer also kept issuing variations that caused delays. Both sides contributed to the delay. So what happened here? Under UAE law, if the delays are concurrent, meaning happening at the same time, neither party gets compensation for that period. It's kind of cancel each other out effect. And the UAE court have been very clear about this. Concurrency means no damages, no compensation for that period, and the rationale behind this is that no one should benefit from its own fault. Now let's talk about subcontractors and liabilities. this is where it gets interesting and sometimes confusing. The main contractor might hire subcontractors to perform a part of the work, but if there is a delay caused by the subcontractor, who will be responsible toward the employer? The answer: under the UAE law, the responsible party will be in principle the main contractor, as on one hand, the only existing relationship is between the main contractor and the employer. The employer has no contract with the subcontractor. And on the other hand, UAE law provides for main contractors liability for the default of any subcontractors, and makes no distinction between the case where the subcontractor is selected by the main contractor or is nominated by the employer. Even if the subcontractor was nominated by the employer, the general rule under the UAE law, the main contractor remains liable. The employer cannot sue subcontractors directly because there is no contract between them, and vice versa. Of course, in practice, things can get more nuanced. Some contracts contain specific or special provisions about nominated subcontractors. Courts would take into account whether the subcontract was nominated by the employer and whether there is any express term under the contract stating that the main contractor will not be liable for the default of the nominated subcontractors. In the event there is such a clause, an agreement between the parties, the court will most likely enforce such clauses, as the responsibility of the main contractors and the subcontractors are not of public order nature. Hence, can be agreed to the contrary by the parties. I've personally seen cases where the main contractor argued, I didn't choose this subcontractor, the employer did, so why should I be responsible for this? Therefore, the safe approach is always the main contractor is on the hook. For us as lawyers, the golden rule is always look at the terms of the contract. See how risks were allocated. Sometimes contracts make specific distinctions about nominated subcontractors. And if they don't contradict public policy, the courts will usually enforce them. Now let's shift to another big issue, money. Construction projects involve massive sums, and cash flow is everything. Main contractors often protect themselves by using what we call back-to-back clauses. So this means the subcontractor only gets paid when the main contractor gets paid first from the employer. So if the employer delays payment, the main contractor can say to the subcontractor, sorry, I haven't been paid yet, I can't pay you now. Legally, this creates some challenges, because if the subcontractors sue the main contractor, the court might say the claim is premature, since the main contractor's obligation to pay hasn't yet materialized, and hence the subcontractor's case will be dismissed. Now, can the subcontractor sue directly the employer? In principle, no. Why? Because of the principle of privity of contract. The subcontract is only between the main contractor and the subcontractor, and the employer is not part of it. And there is a well-established principle worldwide that only the contracting parties can be bound by the contract. The only exception is if the main contractor assigns their entitlement from the employer to the subcontractor. In that case, the subcontractor can stand in the shoes of the main contractor to sue the employer. And in doing so, the subcontractor must definitely produce the assignment agreement to prove its capacity to sue the employer for his case to be admissible. Now let's conclude, let's step back. Today, we looked at the key parties in a construction project, delays and liquidated damages, the idea of concurrency, the role of subcontractors and where liability lies, and finally, the challenges around payment and back-to-back clauses. Now, these are just a few of practical challenges you will see again and again in construction disputes. But remember, construction law is not about reading clauses or citing statutes. It's about understanding the project as a whole, the contracts, the timelines, the evidence, the commercial context. As young lawyers, if you train yourself to combine legal knowledge with practical insight, you will not just resolve disputes, you will add real value to the clients and companies you represent. And this is how you grow into leaders in this profession. You need to approach these cases with curiosity, with attention to details and with a willingness to learn from engineers, project managers, and experts. You will make yourself indispensable to your client. This was only the start. There's so much more we could cover, such as variation, termination, defect liabilities, insurance issues, but we'll save those for future sessions. I really hope this session has given you useful insight and sparked your interest to explore construction law further. Thank you very much for your attention, and I wish you all the best in your journey as future legal leaders.